Let's continue with the story, though, and get you a legal mind on this. Karen Kitchen is a trademark attorney representing Bredenkamp IP attorneys and joins us now via our video link. And Karen, you know, I'm not sure if the situation is any clearer from your vantage point. So Legacy Projects, we understand, has in fact a trademark with this logo of the warrior and the spear. They haven't been consulted by either parties, it appears, in the lead up to the litigation. I'm referring now to the ANC and the MK party. From your vantage point, what are the possibilities around what could take place next in a context where both organizations claim ownership of a logo that's in fact owned, legally speaking, by a third party?
Yes, good morning, and good morning to our viewers, and thank you for having me on the news this morning. So there are certainly a number of issues here, and the plot certainly thickens.
Yeah.
I think if I may just start with just some basic trademark law principles. There are two different types of trademarks. There are common law trademarks, which are established through use, and then there are statutory trademarks, i.e. a trademark that is applied for and potentially registered by way of the trademarks register with the CIPC. On the face of it, we have a registered trademark that has been, was filed in 2014 by a party called Legacy Projects, and it proceeded to registration in approximately 2018. Now, they appear to me to be the only party out of these three parties that has a registered trademark right. However, we must also bear in mind the common law trademark right position here, i.e. which party has prior rights established through use over, say, an extended period of time. Because at the end of the day, the party that has the prior rights is the party that is likely to prevail in this litigation. So whilst there is a prima facie registered trademark right that has been secured by a third party, being Legacy Projects, there is still a question mark over who has the prior common law rights, because those could prevail over a registered trademark right.
Interesting. And I suppose in relation to that, we're told the ANC has brought forward what's called a Class 45 and 36 trademark application. I wonder if that means anything in your world, but it all sounds like Latin to me. But the bottom line here is that part of what the ANC has argued is that they enjoy goodwill from the logo and in fact have continued to use it even after Umkhonto weSizwe, the military wing itself, was disbanded. And judging from what you're saying, they may very well be onto something, at least legally speaking.
Yes, so just for our viewers, just so they understand what this classification relevance is. So when trademarks are filed on the by way of the CIPC's trademarks register, they are filed in various classes depending on the goods and or services that that party applies their trademark to. So you are quite correct. On a quick review of the trademarks register this morning, I noted that the ANC has filed various trademark applications for the Umkhonto weSizwe word trademark in various classes. There are 45 classes that one can file in. Legacy Projects secured their registered trademark in Class 41, as the previous speaker mentioned, which generally covers cultural activities and entertainment, etc. The ANC has applied for the Umkhonto weSizwe word trademark in more than just Class 36 and 45. It's actually applied for it in a number of classes. I did a quick check and they've filed it in Class 25, which covers clothing, footwear, and that kind of merchandise. They filed it in Class 35, 41, and 45. Generally, they've covered a broad spectrum of goods and services for this trademark. So they still have a pending trademark application, whereas Legacy Projects has got a registered trademark in a different class. So now it's a question of where does it go from here?
Right.
A common law right would. Sorry. Go ahead.
No, please, I was just agreeing with you. I mean, that is the question, right? What happens now?
So again, we faced with two issues. On the face of it, the ANC probably has a stronger leg to stand on by asserting, as they say, a goodwill and a right of use through an extended period of time. What makes matters a little bit more complicated is, as you pointed out, when the paramilitary wing, Mkhonto we Sizwe, was disbanded in 1993, arguably one could say there was interrupted use, and the ANC potentially stopped using that trademark in both the word form as well as the logo itself.
Does any party have to consult legacy projects in order for all their bases to be covered? And I'm asking this question knowing, by the way, that apparently they haven't, or at least not to a point where there's been some kind of formal agreement around what will happen. But from your vantage point, if any of the organized, let me ask the question differently. Could there be a spanner in the works if legacy projects somewhere down the line comes forward and asks to be involved in this litigation, barring either of the parties from taking ownership of the logo?
Yes, so there are some complexities, and it's all a timing issue, really. What the ANC would need to do is to file a trademark cancellation, proceedings, which would generally be done through the Pretoria High Court, because the CIPC is situated in Pretoria, and that is essentially the body that holds these trademark rights on its register, etc. So the ANC would have to expand or cancel this registered trademark right by asserting that it has prior common law rights, and it will need to do that at some stage, because the ANC, as I mentioned, has now filed various trademark applications during 2023 that will go through an examination process now, and it is likely that those will be refused on the basis of the Class 41 registered trademark right that is in the name of the legacy projects. So it will be interesting to see, in terms of timing now, that would be the kind of next step that the ANC should be looking at actioning, because only once that is invalidated, then they have a clear path to get their statutory trademark rights through to acceptance, advertisement, and ultimately registration.
Gosh, Karen, it doesn't sound to me like all of this could be done before the 29th of May.
Absolutely not.
Definitely not. That is going to be a time-consuming process, and there are no grounds of urgency here on the face of it and on my review of the matter. So it is going to be tricky, and it's going to be interesting to see what the Durban High Court has to say about these matters, because they are not straightforward.
Absolutely. Well, Karen Kitchen, we appreciate your weighing in and helping us connect the dots, as it were, especially for us mere mortals who are not in your world, where these things can get very complex. Karen Kitchen is a trademark attorney speaking to us there via our video link.